well, we can't honor that power of attorney because it's not on our form. Well, wait a minute. What does that mean? Hi, Jeff Mersace, the Plain English Attorney, and I am here in the great state of Wyoming where everything is wide open. So, of course, I'm going to talk about why powers of attorney aren't necessarily wide open when you're dealing with the bank or other financial institutions. And this is something that's been happening and developing in recent years, where people will go into a bank with a power of attorney because someone's now incapacitated, and they may hear, well, we can't honor that power of attorney because it's not on our form. Well, wait a minute. What does that mean? Here's why this sometimes happens. It's because powers of attorney are designed by the legislature. Here's where it works. If there is no kind of pre-existing contract, then the power of attorney will allow someone to step into your place and deal on your behalf. So if there's maybe something with the electric company and you need to switch something around, but the person's incapacitated, you need to cancel service, move it somewhere else. Oh, they need to sign it. Well, wait, I've got a power of attorney. Oh, it's okay.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
When you're dealing with banks and financial institutions, a lot of that starter paperwork to open accounts, that's going to have somewhere in there, typically, we can change the terms and conditions whenever we want. Unfortunately, that's just the way it is when you're dealing with a bank or a financial institution. It's largely take it or leave it. And then somewhere when they send you like every 8 to 16 months, here's some fine print changes to your account. This is important. Read this. Somewhere in there, it probably said, we now have our own forms for power of attorney. You need to fill them out if they're going to be honored here. Otherwise, they're just going to say, no, you need to go and get a guardianship so that a court is actually ordering us to listen to you. That's the way it works. So how do I counsel my clients on this, especially if they're using a revocable living trust? Well, when they're in this funding process, meaning putting assets into the trust, there might be an account that's just going to be easier for them to leave outside the trust but make payable upon death into the trust. If the account goes into the trust, the bank has accepted that the terms of the trust are going to govern who's in charge. That's the way that works. If it's not in the trust, then that contract with setting up the bank or the changes that were made saying you need to use our power of attorney forms, that now controls. So when my clients go in, it's like, okay, yeah, we want this account moved into the trust and this moved into the trust, but this one's staying outside the trust. My recommendation is bring your big blue binder, give them the powers of attorney and say, hey, we want to make sure that this is okay. Keep it on file. That's the point where the bank may say, oh, well, we have our own forms. Great. Bring those forms out and we'll fill in exactly the same people. So now that's covered. So that's how powers of attorney are going to work when you're dealing in particular with the bank, but sometimes other investment companies may have similar rules. Just having a power of attorney may not be enough. Check with the financial institution to make sure. And if you want more information on funding a trust, check out the trustfundingcourse.com or go ahead and check out the free webinar at trustfundingwebinar.com. Thanks, and as I always tell my clients, stay safe, plan ahead, and enjoy life, and whatever you do, make it a great day.